All right, welcome back, everybody, and to those of you who are joining us for the first time today, welcome. I would encourage you. I've said this already to a couple of people who couldn't make the first part of the program. It will be recorded, and I definitely encourage you, if you're interested at all in the topic of upholding the rule of law, which hopefully all of you are, to listen to the first panel and to our amazing keynote speaker, Scott Cummings. So this panel is about lawyers who have been pushing back in court on the administration's actions, what they've been doing, why they've been doing the cases they've been doing, and some of the limits of litigation. We already heard in the first panel today from two lawyers, Gary DiBianco and Brenna Trout-Frey, who are bringing cases into court. So this is a bit of a continuation of that. And also really focusing to a greater extent on what are some of the limitations of that, and that will lead us into our final panel. I'm going to briefly introduce our panelists today. I heartily encourage you all to read their full bios that are in the program to get a sense. If I went through all of their accomplishments, there would be no time for them to speak, and we don't want that. So first, I think on the far side here is Elena Goldstein, who is the legal director at Democracy Forward. And hopefully we'll hear from her a little bit about what Democracy Forward is doing. And she was previously the deputy solicitor for the Department of Labor and deputy chief of the Civil Rights Bureau at the New York State AG's office. And again, like I said, these are just a few things about each of them. Next, we have Lee Gallant, who's the deputy director of ACLU's Immigrants' Rights Project, has argued crucial immigration, media access, and national security cases before the Supreme Court and Circuit Courts of Appeals. I hate to make Lee blush in front of everybody, but I will say that my colleagues who do immigration work were thrilled that he was coming here to talk about some of the work, the amazing work the ACLU is doing. Next is Judge Nancy Gertner, who right now is a senior lecturer in law at Harvard, but is also an author, is a former district court judge, and even before that was a civil rights lawyer and a criminal defense lawyer, and so can speak from multiple perspectives, has written many op-eds, and as well as a book on women in the law. And then on screen joining us is Lauren Racklin. She is the executive director at Lawyers Defending American Democracy, author of 4 books and hundreds of articles and opinion pieces. And we will hear from her on some of the amazing work that LDAD is doing as well. I want to start off with the mic that works. Oh, there we go. It went. Thank you. Yeah. So I want to start off first with questions for Elena and Lee, and the reason is that they're both very much the tip of the spear in terms of the litigation that's happening to fight back against some of the attacks on the rule of law. And one of the things that I particularly noticed is that the lawyers out there who seem to be much more comfortable with these attacks that are happening on lawyers are the lawyers who've been doing work that has been attacked for ages and decades. And that's legal services lawyers and public defenders and immigration lawyers. And those are the lawyers who have already really developed a lot of backbone when it comes to dealing with governmental actions that they find unfriendly for their clients. And so I actually think that a lot of the lawyers who are at firms would do well to get counseling and mentoring and advice from the lawyers who have spent their careers doing that kind of thing. And so I wanted to start off with them, and then we'll also hear, of course, from Judge Gertner and Lauren McLean. But Alina, why don't I start off with you? And just for people who don't know, can you give a little bit of background on Democracy Forward, and then also some of the litigation work you guys have taken on?
Happy to do that, and really glad to be here. So excited to see so many people who are interested in this issue. And I think that needing to be interested and engaged on these issues, whether you are a law student or a lawyer or not, is really the first step in what we need to start to oppose what is happening all around us. So my name is Alina Goldstein. I will give a little bit of background about Democracy Forward and talk a little bit about some of the work that we are doing. So Democracy Forward Foundation is a national legal organization that seeks to advance democracy and social progress through litigation, policy, public education, and regulatory engagement. We were started during the first Trump administration and have grown to a staff of over, I think it's around 150 people in this administration. I think we've doubled in size since I joined the organization less than a year ago. We host a number of different projects at Democracy Forward, including something called Democracy 2025. This is really a coalition project that is aiming to bring resources, doctrine trackers, template documents to a coalition that is now more than 650 organizations strong. And the goal is really to support other organizations and to build them up to help them do this important work too. There are working groups on issues like civil rights, immigration, threats to data integrity, and more. We also have a project called Civil Service Strong, which is a resource center that's designed to help support public servants. And you guys just really have to speak into the mics. I'm just gonna lift it up so I'm not crouching. Is that okay? Even though I'm 5 feet tall. Is that better?
Yes.
Okay.
Yes.
So Civil Service Strong, as you've seen, so many federal workers are being targeted and fired. And what Civil Service Strong tries to do is to provide resources and support, links to free legal services and the like. I am going to talk mostly about our litigation work at Democracy Forward to support the rule of law. Since the beginning of this administration, and these numbers are out of date, we have filed more than 100 legal actions along with our coalition partners. We've launched more than 200 investigations, issued more than 1,000 FOIA requests. And we have obtained some significant victories. I know some of the questions earlier today were really about what courts can do in this time, and hopefully we can get more into that a bit later. But I think some of the victories that we have won, some of the work that we are continuing to do, even in the face of difficult Supreme Court decisions, are really important. So I'll talk about just a couple of buckets of work that we've been doing at Democracy Forward. The sort of first bucket is fighting attempts to dismantle the government. So as folks know, this administration has really been taking a host of actions designed to effectively dismantle the federal government as we know it. And we have filed a whole host of lawsuits challenging those actions. Some of those, like the challenge to AmeriCorps, in which we represent, along with coalition partners like Brenna, a group of unions, of grantees who receive AmeriCorps funding, of individual participants who were yanked out of their service year projects mid-year, challenging that dismantling of the agency. We received a preliminary injunction in that case that has not been appealed. So those students are back to work, those grants are now flowing, and those 85% of AmeriCorps employees who were issued reductions in force notices, they're still working. And I think it's a good example of a case where the administration, when they realized they were cutting a program that was profoundly popular and important to communities around our country, backed down. There are other cases like the efforts to dismantle the Department of Education case, so the USAID case, where we have received some negative decisions further on down the line from the Supreme Court. But I will say that, with respect to the US Department of Education dismantling, where the federal government has sought and is now fired roughly half of the folks that work at the Department of Education, received a preliminary injunction in the district court affirmed by the First Circuit, and then that stay was issued a stay by the Supreme Court with no reasoning. We are moving into a second phase of that case, which is discovery, and trying to get the federal government to give us reasoning and explain what is happening and why it is happening. And I think that that is a really important goal that you will hear about litigation as we're talking here, the importance of shining a spotlight on what is happening inside. I'll talk briefly about one of our other dismantling cases because I think it is both really interesting and important. And that is the efforts of this administration to really reorganize the entire federal workforce. There was a reorganization executive order in which the president, at the outset of the administration, directed agencies to take all of these massive reductions in force across the administration. Now, Congress creates agencies, and historically, presidents have gone to Congress to seek authority and statutory authority to reorganize government. The Trump administration did that in the first Trump administration, and Congress did not give that authority. The president did not ask this time, instead just issued an executive order, directed agencies across the government to slash themselves. We obtained, again, with a giant coalition of partners, including nonprofits, including unions, including other nonprofits that were challenging this alongside of us. We received an injunction that, as the federal government said, stopped more than 40 reductions in force at 17 different agencies. Now, that injunction, too, was eventually stayed by the Supreme Court, but the reductions in force and the reorganization efforts that are rolling out now are nowhere near as large as what was happening before, as what was planned at the outset. And I think the work of lawyers to slow down these really ill-conceived ideas remains really important. Another really big bucket of work is defending federal funding and the critical services that it provides to folks in this country. We're seeing this play out in lots of different ways. One involves unlawful funding conditions. So we're increasingly seeing the administration attach federal funding conditions on grant programs that Congress has created that don't belong there, that have no basis in statute. So let me give you one example. There's a grant program that provides support to localities to build permanent supportive housing to reduce homelessness. The federal government has now said that you can't even apply for this grant if you are in a jurisdiction that doesn't criminalize homelessness, that doesn't cooperate with federal immigration officials. Those have nothing to do with the statutory parameters of that grant. And we just received a temporary restraining order ordering the federal government to take down those selection and application criteria. We're also seeing just blatant efforts to freeze and impound and hold on to federal funds. So we filed a lawsuit representing school districts, teachers unions, and nonprofits challenging more than $6 billion in education funding that the federal government just refused to release to states and localities. After that was filed, it's another good example of public outrage causing change and lawsuits putting pressure on the administration to change. They've released those funds. And then, lots of other examples I'm sure folks have heard about with respect to freezing billions of dollars in funds that were designed to reduce energy costs, support clean energy manufacturing, grants all across the board. I'll highlight one more grants example that's relevant to lawyers in particular, and I think highlights a pattern of retaliation that we are seeing from the federal government over and over again. There was a case earlier this spring where the Department of Justice canceled grants to the American Bar Association. These were grants that provided training to lawyers and judges that work with survivors of domestic violence and assault. And it happened a day after the Deputy Attorney General issued a memo that singled out the American Bar Association for support of activist causes. It was direct retaliation for what the Bar Association, like lawyers should be doing, standing up against this administration. We won that case. The Department of Justice did not appeal. And then there's a host of other kinds of cases. I think the through line of our work in this administration has really been that there is so much that is unprecedented, work that does not fall into sort of traditional civil rights, civil liberties kinds of buckets, though plenty that does with that too. But cases involving DOJ access to Social Security and other data. We won an injunction last week that prevents the IRS from sharing information with ICE. There's immigration cases alongside our colleagues at the ACLU and others, and I'll let Lee talk about those. Cases defending the nonpartisan civil service and efforts to remove folks who have civil service protections and replace them with partisan aligned individuals in a way that violates the merit protection system of our federal government. There are also cases where we are seeing the federal government engage in what we see as collusive settlements in states. So there is a Texas law that allows for in-state tuition for undocumented immigrants who reside in Texas. This is a Texas law that has been on the books for a long time. They haven't been able to change it politically. The United States recently filed suit against Texas saying that that law was illegal. Texas immediately agreed and said, we'll settle this case. This is a way for us to get this law off the books without going through the political process. And that's a case where we recently filed a motion seeking to intervene in that case. But a lot of actions like those that are not getting the headlines, but are ways in which this administration is trying to circumvent the political process in order to achieve their political goals, we're seeing across friendly states for them. Lots of other cases, but I will stop there and just say we are very busy.
Yeah, you're being kept very busy. And I think Lee as well, you're being kept exceptionally busy in terms of so many of the administration's policies and actions with regards to immigrants. And I wonder whether you could tell us a little bit about some of the cases that are top of mind for you right now. That you're handling. I feel that since even before this administration took office, the ACLU was getting ready and prepared, and I don't know if you were and could have been as prepared for all of the attacks that came, but which are the ones that right now, oh, and I should say, I was worried Lee wasn't going to be able to make it because it could have been called in for an emergency hearing at any time. So the fact that you're here is wonderful. And please tell us about which cases for you are at the forefront of your mind right now.
Yeah, thank you so much for having me. And it's good to, as I said, it's good to see all of you here and engaged. I'm hoping, and I think we will pick up on some of the important points that Elena raised, because I do want to talk about litigation both in terms of actual winning to stop a policy. That's great. Obviously, that's the goal, but also slowing down implementation, but also even losses, getting an issue out there and telling stories and trying your best to get the human dimension of what's going on out there. Because litigation can be an important vehicle for storytelling and getting the narrative out there. And I hope we're going to talk, and I think we will, about the narrative around various issues and how that affects what's going on. But just briefly, some of the issues that we're working on, there's birthright citizenship, of course. I think I'm not going to go on and on about that. I think everyone knows there's the birthright citizenship cases going on, right? The administration has said if you're not, your parents aren't a lawful permanent resident or a citizen, you're not going to any longer get birthright citizenship from being born on U.S. soil. That's ultimately, I think, heading to the Supreme Court. All the lower courts have struck it down and said there's past Supreme Court precedent on it, and that's what we're going with. We'll see what the Supreme Court does. You know, everyone, her mother has filed a lawsuit on that, maybe because they think that's the one winning case for our side, but we'll see. What I want to talk about also is the Alien Enemies Act, which is at top of mind for us, and we're doing it with democracy. That is a law that I did not know anything about before before the campaign. Just I think to Theo's point, we did prepare a lot, and we can talk about that later. The first time around, the ACLU does briefing books on the two candidates. The briefing book for Secretary Clinton was, big, and for President Trump was tiny, and we got caught off guard like a lot of people, not expecting that. This time, I obviously knew that President Trump could win, and so we spent almost a year preparing for virtually every issue that's come out. But I don't know that we were necessarily prepared for the pace of it, and there's obviously some issues we weren't prepared for. The Alien Enemies Act is a law that was passed in 1798. And as we see it, and as the courts thus far have seen, it's supposed to be used during wartime. It allows you to declare every national from a country we're at war with, or has invaded us, or is engaged in what's called a predatory incursion, which we think all are sort of forms of military invasion, to declare every one of those nationals an alien enemy. We've invoked it 3 times in our nation's history: the War of 1812, World War I, and World War II, and infamously in World War II when a lot of Japanese non-citizens were detained. That's, in our view, obvious proof, but we'll see what the courts think, that it was never intended, and no prior president ever viewed it to go after a gang, but it's being used now to go after Tren de Agua, the Venezuelan gang. And we have said, and so again, so far the Fifth Circuit has agreed with us that it can't be used during peacetime against a criminal organization. It's meant when the U.S. is at war. But the president has invoked it to detain and deport anybody they declare to be a member of this gang. And at first, they shipped off people in the middle of the night, and we had gotten into court. The court said, turn around the planes. The court didn't. We can talk about, I think, the role of judges and the executive branch resistance to court orders, or trying to get around court orders. I think that may be something we want to talk about. So hundreds of men ended up in this notorious terrorism prison in El Salvador, Sacat. Many of you may have seen videos of the men being taken off the planes, their heads shaved. Turns out that most, if not overwhelmingly, the people were not members of the gang, had gotten no due process. We don't think the act can be used at all during peacetime, but even if it can, people have to be able to show that they're not members of the gang. The government originally said they don't get even that opportunity. There was blowback, including from all spectrum. Joe Rogan came out and said, well, what if they're not gang members? Don't they need a chance? We went up to the court said they need a meaningful opportunity to show they're not gang members. The government responded saying, we'll give you 12 hours. We'll give you notice in the middle of the night. If you don't get into court by the morning, then you're going to be gone. We had to go back up to the court, got a 1 a.m. Stay, keeping the men here. The Supreme Court has kept the stay in place. We've been litigating in the lower courts. There's a test case in the Fifth Circuit. We just won 2-1. We'll see if they go en banc or go to the Supreme Court. But one way or the other, I think it's going to end up back in the Supreme Court. And it's obviously attacking immigrants directly, but it's also, I think, a bellwether of how much the Supreme Court's going to allow them to simply declare invasions and use military law. And so if they get away with that, I think it's going to send a bad signal that they can do that kind of thing. Relatedly, and I think this case has gotten much less attention, but in any other time, I think would be worthy of a lot of attention, is the president's signature proclamation when he took office to close the border. And what he did is he said, I think migrants are invading our country, therefore I am ending asylum. So for those of you who are not steeped in immigration, asylum is basically protection against persecution in your home country on various grounds: religion, race, political opinion. Except for a short period during COVID, and even that got struck down, the United States has always offered people a screening for asylum. This proclamation ends asylum across the board. There is no pathway to seek asylum. You can come to the border and legally apply. No, you show evidence that you are definitely going to be persecuted, if not killed, based on your religion. You can't apply. And we made a solemn promise after World War II that we would never again turn people back without at least a screening. So this is an enormous issue. We're now a handful of countries, and you can guess which countries, North Korea, a few others, that don't offer any protection for immigrants seeking refuge based on persecution. I think that it's important not only because the president has unilaterally said he has the unilateral power to declare an invasion and therefore end all asylum and shut down the border, but also just because, I mean, that's obviously the practical importance of the people at the border, but also just the president once again saying, I have the unilateral power to declare an invasion and invoke whatever power he wants. I'm just gonna quickly knock off a few other cases. I know we're short on time. The president has also now said that even if you're in the interior of the country, you get no due process. You can be removed if you can't show you've been here more than 2 years. So you could be sitting anywhere, in a restaurant, anywhere at work, and if you don't have papers showing that you haven't been here 2 years, you could be swept up and removed immediately. Maybe you get a chance to say, I'm going to be in danger and apply for something. Maybe not. And so we have challenged that on due process grounds. So far, we've prevailed. That is a long way to go before we see what happens. But it's another instance where the administration is basically trying to eliminate all due process. Family separation, which was sort of the big case during Trump 1, when they separated 6,000 little children, including babies and toddlers. We reached a settlement with the Biden administration. Trump administration is repeatedly breaching it, so we're back in court all the time. And that were separations at the border. They're now also doing it in the interior, so it may require us to bring yet another offshoot of that lawsuit. So I think it's just, in the through line, I think, sort of, as Elena said, her cases have a certain through line. And for immigration, for us, there's obviously the systemic questions about basic constitutional rights, such as rights, but what I'm seeing as a through line is sort of the attempt by the administration to desensitize the public to immigration and to dehumanize people. And I think that's what we should talk about, the narrative, because at the border, they're basically painting this picture of everyone coming here as coming to do harm. Obviously, that's not true. And you ask people, what about the border? And they say, yeah, well, the border is chaotic. We need to fix it. But if you actually say to them, but what about a family who's being persecuted because they're Christian and will definitely be killed if they're sent back? Well, of course, that family should have screening. So it's a little bit of, and I do think this is a major issue for us, is the challenge to get out the facts, to say what exactly the policies are doing. People ask me after the election and after inauguration, well, now you won't really be able to do much on immigration. The public has voted for more immigration enforcement. And of course, that was true as a general matter, but what I always said is that they really voted for an abstraction and it was too vague, and that our job was to show what it would look like in practice. Obviously, the president is saying we're only going after the worst of the worst. That hasn't been true. It's not remotely true, but we are failing as advocates if we don't get out the fact that they're going after people who are not the worst of the worst. Families who have been here 30 years, paying their taxes, may have U.S. citizen children, one after another, kind of those extreme situations, and including our case in LA, where they are basing stops on ethnicity and where you work. So that's our job, I feel like, as much as going into court, is to get out the fact that you may have wanted more immigration enforcement. Did you really want this? And I think when people now see what's going on, they say, well, that's not exactly what I thought was going to happen. So that is as much our job as going into court and trying to win cases.
Yeah, and we're going to come back to sort of what both of you guys alluded to, which is this fire hose of issues that need to be taken on, and how you sort of, with good resources, but not infinite resources, decide which are the ones to take on. And also to come back to this idea that winning in court isn't the only purpose of these cases, the storytelling. And we're definitely going to come back to both of those. First, I want to give Lauren Reclean a chance to talk a little bit about the work of lawyers defending American democracy, which is taking, and in particular, a lot of the work that LDAD is doing in what we've alluded to throughout this symposium, which is holding lawyers who are enabling the backsliding, the rule of law, accountable, and the role of LDAD in doing that. And I know LDAD does more than that, and we will come back to some of those other things, but maybe just start out with that, Lauren.
Thank you. Sure. I I'm really sorry that I can't be there in person with everybody. I really would have loved to have been there. And I appreciate the amazing keynote address from Scott, and appreciate his reference to this accountability work and LDAD's work in particular as well. This is, as you yourself said, a piece of what LDAD does, an important piece, of course, but one piece in a kind of larger pot of advocacy related work. But for us, the core fundamental principle here is the need to hold lawyers accountable, hold them accountable to their oath, to uphold the Constitution. Every lawyer takes that oath, except for, I believe it's 4 states where the oath is a slight variation. It doesn't talk about the Constitution, but I think we can infer it. And we all have to abide by rules of professional ethics. That's the fundamental principle. So when we started getting involved in this work in the in the first Trump administration, and Scott beautifully went through the way in which the undermining of the 2020 election so set the stage for what has followed. And he, in fact, identified several of the key actors for which we filed very meticulously researched and detailed complaints. In particular, Giuliani, Eastman, and Jeffrey Clark. And the whole point is, first, because they should be held accountable for what they did, and we are still paying the price of that foundational damage that they have done to the country. And even if they don't care about their own license, and anybody that we bring actions against, the question has come up, well, what if they don't care about practicing law ever again? For us, the fundamental point is lawyers care about their own licenses for the most part around the country, and they need to understand that when you violate the rules of ethics, when you violate your oath, that you will be held accountable, that you should have to answer to disciplinary authorities with respect to what you have done. I think that it's also important to add something about this rather than to go into specific cases, because everything is, all the work that we have done is on our website. Every single complaint that we have filed is easily accessible there. I think there are some fundamental principles, particularly for a largely law student or law school related audience, that's important, and goes to the earlier discussion about what would you change, for example, by way of curriculum. We have a professional ethics system in this country that really is created around the notion that I am a client, you're my lawyer, you did me wrong, I'm going to bring a complaint against you before the appropriate disciplinary authorities, and they hopefully will investigate and take appropriate action. These cases are not that. For the most part, these are cases that don't harm me as an individual client. They harm every single one of us as people who live and work in the United States of America. And the complaints themselves are not based on me turning over my documents as a client that shows all the things my lawyer did that was awful. They are based on publicly available information, and they are based on information that any one of us could ferret out and find as the factual predicate. And then, of course, we apply the appropriate rules and requirements that have been violated. This is something that is really hard for most disciplinary authorities in most states to wrap their arms around. They are not used to these. They don't understand them. They don't particularly like them, from everything we can tell. And it is really important that we help educate disciplinary authorities, and that we help everyone who is involved in ethics teaching in law schools to understand that this is a critical part going forward, sadly, for lawyers in training to understand that the rules of professional ethics have ought to be applied to everybody, and we need to help those who are disciplining lawyers understand that this is a different type of action and requires the ability to step away from what they're used to historically and traditionally, and that has been a particular roadblock, and certainly was in the very early days when we first started filing some of these complaints. So the goal is really to think about these complaints as not as both an effort to hold particular lawyers accountable, but to also make a statement to the profession writ large that says that when you are in these key public facing roles, when you represent the President of the United States or are taking major positions that undermine the rule of law, undermine basic concepts such as free and fair elections, and the idea of what zealous advocacy means, which is a whole different part of this conversation, that there will be efforts to hold you accountable, and that people will understand that these are examples of what you should not be doing when you practice law, that you still have fundamental obligations as an attorney to which you must adhere.
Thanks. And I'm going to come back to you, Lauren, with a question about concerns about ethics complaints being weaponized, and sort of the blowback that can come. In particular, there's even executive orders, of course, that are saying, let's go after immigration lawyers because they're so frequently unethical. So telling Pam Bondi that she should be going after immigration lawyers in particular. So I'm curious to hear your thoughts about how to avoid the weaponization of ethical complaints, and in fact, what I'm hoping Judge Gardner can talk about initially is in fact the misconduct complaint that was brought against Judge Boasberg, where Lee has a case or two, and that was filed, and maybe a little bit of background on that, and then as a former judge, your thoughts about what that does to the judicial system and its independence when that starts to happen.
Do I have to be clean?
Do you mean,
I just
are you
wanna
allowed to?
understand. Okay.
Yeah.
The complaint against Judge Boasberg figured prominently in one of Lee's cases, notably the case involving the Venezuelans who were being supposedly sent to El Salvador, and there was a whole brouhaha about whether or not the order was, I don't know whether you read about it, whether his verbal order should have bound the government, even though he reduced it to writing 15 minutes later. They made the claim in court that the verbal order somehow didn't matter, and only the written order, and the written order they claimed to have been ambiguous. It wasn't ambiguous for anyone who knows the English language. Then there was a question of whether or not they could have stopped the planes before they landed in El Salvador, et cetera, et cetera. While the Supreme Court ultimately reversed his decisions on an emergency basis, there were still contempt proceedings against the government for misrepresenting what they were doing, misrepresenting. There was a whistleblower who was actually suggesting that Emile Bove, who then became a Third Circuit judge, had said, you know, if the courts rule against us, F them. That's what I say, do I have to be clean? Just a footnote, as a judge, I love to hear this kind of language in my court. But anyhow, I remember once telling a defendant who was testifying, I'd never heard the F word used as an adjective, an adverb, a noun. I mean, it was so creative. I was mesmerized. But anyhow, so Boasberg was the subject of considerable criticism by the Trump administration. Pam Bondi, the Attorney General, files a complaint against him. Footnote, she announces she is filing a complaint against him, which violates the rules. Judicial misconduct complaints are confidential until they are essentially screened by the appropriate authorities and then become a real case. So point number one, what are you doing? This violates all the rules. Point number two, the complaint itself was, I wrote an op-ed about this because me and Steve Fladdick were ballistic. The complaint said that Boasberg, in a judicial conference meeting, had said that he believed that the Trump administration would not be obeying judicial orders, and that comment somehow reflected his antithesis to the administration, and suggested therefore that he should be taken off the pending cases, reassigned, et cetera, et cetera. That statement, if it were in fact what he said, I believe the administration will disobey my orders, would have in fact triggered none of those consequences, because everyone was talking about how the administration was likely to disobey orders. But in fact, that isn't even what he said. So footnote here, just sort of to give you a sense of the judicial conference sounds like a real decision-making body. It's actually whatever Justice Roberts wants. There is a general meeting of all the judges, not all the judges in the country, but judges who are chief judges, appellate judges, and some representatives of the district court. And it's a very structured agenda. But for 2 of the 3 days, Justice Roberts has breakfast with judges. How wonderful. Boring as hell, I'm told. And Justice Roberts will begin with a question which you think he spent a lot of time thinking about. So tell me what's going on in your courts. That's the opening question. And around the table, judges would say, on this occasion, I know I had information about it. One judge would say, well, are the Marshal Service up to the task of security? Someone else would talk about something else. And Boasberg said, my colleagues are concerned lest the Trump administration disobey orders. My colleagues are concerned, in response to a question that Justice Roberts asked. There was nothing wrong with that. That in fact reflected what his court was talking about. That triggered, it was described as an unsolicited comment, which was false. It was described as a comment in a public meeting, which was false. And worse, even if it was as was described, it wasn't an issue. It was clearly political and intended simply to undermine Judge Boasberg and nothing more. And what people don't understand is that it is easy to say this is just baloney, but to the judge who is the subject of it, it actually matters. I never had the occasion to have a disciplinary complaint against me, but I had one occasion when someone sought a writ of mandamus against one of my decisions. And you go on about your work, but in the back of your head, you actually are saying, how dare you? And it affects you. And Judge Boasberg was a subject, in fact, of lots of criticism. I don't know whether he had an impeachment proceeding against him.
Well, they were. Yeah, I mean, I think just to fill it out, it was, as you said, it was my case. They immediately asked the circuit to kick him off the case, which is unheard of. The president called for his impeachment, which triggered the chief coming out and saying, we don't call for the impeachment of judges just because we dislike him. His daughter's picture was everywhere in the newspapers. He was doxxed everywhere. So it was a full campaign.
Right. And I know this morning you were talking about the role of lawyers in this backsliding moment. There's a role for sitting judges. I didn't quite think that I was going to be doing this, but there appears to be a role for retired judges with really big mouths. And so I thought it was important to say something at this point and say something particularly about Judge Boasberg. I got an incredible reaction from both sitting judges and retired judges, happy that we were standing up and supporting them. So the complaint now will go to, I think, a panel of the DC Circuit. It should be dismissed immediately because its pendency gives legitimacy to the criticisms of Judge Boasberg, so that it should be dismissed immediately, but who knows whether it will be. I think it will ultimately be dismissed. Bear in mind, Justice Roberts was probably sitting next to or close to Judge Boasberg when he supposedly made these comments. So he knows that it is an empty threat. But it is I hate to use the word, but it's weaponizing the disciplinary proceedings against judges in a way that the system should respond to precipitously and should end immediately. But
I don't think anyone who knows you or in this room would doubt that you would have the backbone to use colorful language in response to such a misconduct. But what is your sense? I mean, I know you're very connected with judges. What is your sense of what this kind of complaint has meant to them? Fear, a recommitment of independence, all of the above?
let me put this in a broader context. So there's this complaint. There's also been impeachment, articles of impeachment against judges with whom the president did come out with decisions that the president disagreed with. There's also been, I was at an investiture ceremony a few days ago, and there are judges who are being doxxed. The judges who in fact are ruling in the cases that Elena was talking about are being doxxed. Pizza deliveries in the name of Judge Esther Salas's son. They're being defunded. The judiciary, like other arms of the government, are taking a hit with respect to funding. So there's an issue about whether the Marshal Service will be there to, not defunded totally, but they're certainly, their funds are being cut back. That has happened from time to time as other cutbacks in the government. So no one, not sure whether that's related to this. So they feel under threat in many ways. One of the things the reason why I wrote is not only to deal with judges that are under attack, but the other side, which is to talk about the judges who have been stepping up in an extraordinary way. So notwithstanding the environment that I'm describing, when I first left the bench, I wrote a bunch of articles criticizing judges. This is before Trump. And the articles were about how the only pressure I felt as a judge was to duck, avoid, or evade. All of the things that you're going to learn about in civil procedure about that basically kick people out of court. Statute of limitations, waiver issues, all the kinds of things. And that was the emphasis, really. It was, I was told if you wrote an opinion on anything, you failed. You had to move the case, make sure that people would settle, or make sure that people would plead guilty. And that was the pressure that I felt. The Brennan Center had war games right before Trump too. And I was asked to participate as the judge. And I participated, and I said, don't count on the bench. The bench that I knew, don't count on the bench, was what I said, based on what I had understood. I was totally and completely wrong. So there have been the district court judges around the country, it doesn't matter who has appointed them, have stepped up in a way that has been simply extraordinary, and not just ruling in favor of the plaintiffs who are challenging the things that Elena was talking about and that Lee's been talking about, but also the way they have done it. I mean, one judge describes with respect to one of the firings, he said, the Office of Personnel Management does not have any authority whatsoever under any statute in the history of the universe. Another said, ruling on Trump's efforts to end birthright citizenship, the order was flagrantly unconstitutional. And I wrote in this piece, you don't have to be a partisan to rule as these judges do. You only have to be a sentient human being. So what we've seen in the early days of the first 6 months is judges, district court judges, really step up to the plate in a way that has been extraordinary, particularly given the environment I have described. And that's so, again, no matter who has done the appointing from for the most part, from one end of the country to the other. And I believe they still will. The first couple of cases were emergency orders, TROs, preliminary injunctions. What I've been seeing now, Judge Young was one of the first in District of Massachusetts, is to say to the Supreme Court, okay, you're not treating our emergency orders with any respect. So we're going to combine the preliminary injunction with the trial on the merits. We'll have hearings. We'll have findings of fact, conclusions of law to first-year students. That has more heft because the judges conclude findings of fact can only be reversed for an abuse of discretion. Right? I heard the witnesses. I saw the facts. I read the evidence. The Supreme Court may not like where I ended up, but you certainly can't say that those findings were wrong. And so there's that move. Now, of course, that hasn't stopped the Supreme Court in some cases. But so they have really met the moment in a way that is really extraordinary.
I was wondering if you were going to allude to the Supreme Court at the end there, because you were talking about the district courts having been admirable. And I want to turn back to Elena and Lee, either of you or both of you, in terms of when you see these cases, and both you're sort of getting the government that might disobey orders of the district court, and then these cases where you get these really important stays for your clients, and then those stays are lifted without any sort of decision in the Supreme Court. And this goes to what both of you raised and alluded to, the other values that might be in these cases, besides doing all of this work and getting a good outcome for your clients and seeing that go with the snap of a finger with no reasoning. That's a lot, but for both of you, I'm really curious to hear how you hold up in that.
So the first way that I'll answer this is just honestly and say that it's brutal, right? You know, we are consistently winning, as Judge Gertner has noted, in the district court, getting these decisions that are thoughtful, that are long, that are based on, you know, often hundreds of declarations that we're putting into evidence. And we're ultimately getting stays in some of our cases, but again, not all, that have no reasoning whatsoever, leaving the district courts in a situation of trying to sort out what is still live in this case and how do you proceed. But I think that there are lots of ways of thinking about success in the moment. I think some of it is the sort of all-out victory, right? The Department of Education giving up $6 billion in funding that it was not giving up before. That's a victory. I also think slowing things down is a victory. The fact that the federal government is not engaging in their 40 RIFs at 17 agencies, that's a victory. More people have jobs than would not have had jobs if the government was allowed to go as fast and as loose as it originally tried to do. But I think one of the biggest goals, and I think Lee pointed this out earlier, is just shining a spotlight and attention on what is happening. We are in this moment where so much is happening all of the time, and so much of it is happening in ways that are difficult to see and difficult for folks to keep paying attention to. And so to be able to tell these stories, both about the complaints we're bringing and the plaintiffs that we're representing, but also even after one of those stays in the Supreme Court, going back to our district courts and asking for discovery, asking for depositions, asking to put the federal officials who've made these decisions on the stand. And we're, you know, in one of our cases, I think we had a high-level deposition this week that I can't talk too much about, but we are getting information and we are putting information out into the world. And I think that that is itself a real victory and a real goal. I also think, and this goes to something that we discussed earlier, the sort of what do we challenge question. I think there is value in just standing up and saying that some of this is wrong. And I think that that's becoming very difficult to do because there's so much of it. But I think that just those acts of resistance are really important too, an important part of these litigations.
So I agree with all that. The only thing I would add, which I think Lane would agree with, is it's a challenge how to get it out there, right? There is so much going on. The public's attention is only so much, right? Just understandably, there's just too much, and there's also some feeling of they just want to turn away. Same is true with the media. And so how to actually break through and get people to pay attention is critical. So it's not, you know, putting it out there is the first step, but how to do it. And what I have found over my career is that you can put out things that are, you know, for you all, it resonates immediately if we put out something about the rule of law, but not for the general public. They're going to flip the channel pretty quickly. And to put it out there in a way that's compelling in human terms, because I do believe, you know, there are obviously segments of both sides where you're never going to reach people. But for the most part, I feel like you can reach people with human stories. And I just go back to family separation during the first term. In the beginning, everyone thinks it it ultimately became a sort of worldwide issue with the Pope speaking out on the front page of every paper in the country, day after day after day, the morning shows, the night, all of it. But when it was an abstraction, it was hard to get people's attention. And I remember walking into one of the cable networks, I'm not going to say which one, to go on air for a different issue, but mention, we just filed this suit. The Trump administration is taking children away from their parents. And I couldn't get people's attention. But when we finally got the stories out, so we, told some of the stories of a mom with an 18-month-old. They made her strap the little boy in the backseat of the ICE vehicle, and she wasn't allowed to comfort him. And they drove away. She could see her little boy craning his neck to get one last glimpse of his mother. Another family, 4-year-old boy who had glasses and modest means, they were able to scrape together the money to get a glasses case. And they came to take away the little boy. He was begging not to let them take him, but fortunately he was wearing his glasses, but they didn't let the mom get his glasses case. So all day long, all the mother thought about is, will they show my little boy where he can put his glasses so they don't break? Can my little boy see? Will they get him a new pair of glasses if they break? Another father asked, can I just have 1 minute to tell my 7-year-old boy what's going to happen to him? They didn't give him the minute, so the little boy is holding onto the father's leg and they're pulling him away. He's not knows where he's going. And so we were able to break through and conservatives and liberals, Republicans, Democrats, conservative religious leaders, as I said, the Pope came out and said, wait, this is too much. And, if you had presented it in a sort of abstract way, what rights do immigrants have, I don't know that we would have got that. So I think the task for us is to really get the stories out in a human way and to show that we're talking about real people, because right now the administration has been winning by just saying these are the worst of the worst. They throw out a few stories and they hit that sort of visceral thing of, oh, I don't want these gang members coming into my neighborhood. So it's incumbent upon us to show who these people are and the real effect of the policies.
Just one other thing with respect to that, this is not the topic of today's discussion, but the fleshing out these issues in court enables a political resistance. Not just you're talking about people who know about that, but people can then organize around it because you have now put it in terms that people understand. We know litigation, we know rights talk, and then that feeds into what's going on outside the courtroom, not just on the media, but demonstrations outside the courtroom.
Yeah, for sure. And I was just going to say that I think for me, that was the one real civil rights moment that I saw. I think we're starting to have more now, but where people really took to the streets in every city across the country saying no more family separation. And it had an effect because the administration ultimately didn't appeal the district court's ruling that this was blatantly unconstitutional. And I think that was in significant part the pushback. And ultimately, President Trump said, oh, well, we're not going to do family separation anymore. Of course, they were still doing it. So we needed the injunction, but it was a lever for creating that kind of resistance beyond the courts.
And I think connecting stories to the public consciousness is such a valuable part of litigation, but it's very kind of spotty and sort of depends on whether you have sort of a good moment to bring there. Also, it's not necessarily what lawyers are trained on. And I know Eldad, and I want to turn it back over to you, Lauren, you have a particular initiative about lawyers connecting more stories to the public consciousness, and I want to give you a chance to talk about that.
Yes, thank you so much. And, this point about breaking through is, I think, the biggest frustration that all of us face. Because not only is it difficult to break through because of the overpowering nature, which is their point of what they're doing, but then the media will, hyperventilate over a story for days at a time while so much else is happening that is worthy of attention. One of the initiative that we are trying, creating to combat this effort is called Meeting the Moment, appropriately enough. And it's founded on the principle that lawyers have this special obligation to speak up when democracy and the rule of law are threatened, and that lawyers should be leading by inspiration and by example. So when we talk about LDED was created to galvanize the legal profession, well, yes, but the next question is to what end? And I think for the Meeting the Moment purpose, that end is to galvanize the legal profession to help the public understand and engage with the public over exactly what is happening today and why it matters to them, why judicial independence is something that is not an abstract concept, but has everyday meaning in their lives. Same with due process, same with the rule of law. And we're creating this initiative where we have volunteers across the country, in every state, and trying to engage businesses, faith-based communities, our networks, bar associations, everything, every way that we can to have people start to talk about and focus on what is going on, and particularly to speak in similar messages as a way to try to break through the disinformation, to have uniform rapid responses on certain topics, certain issues, with language that we can all use that can help break through all the lies and all the disinformation. That's a daunting task, to be sure, but it goes to the grit in the gears theory, which is we all have to do the best we can. We have to lead by inspiration and by hope. And we hope that we can galvanize lawyers to inspire their communities to be able to understand why this matters, to take those heartbreaking stories that Lee just told and make people understand not even those stories alone, but how all these actions are impacting all of us in so many ways. And if I can just add one quick thing, because you had raised before about the argument about weaponization. One of the things I think, and that's part of our hope with Meeting the Moment, is that we have to think about these words that are always used against the pro-democracy forces, but never with respect to the anti-democracy forces. So questions come up about, well, are ethics complaints being used to weaponize, and won't that hurt you down the road? No. And we can't always, we have to fight back about being in a defensive posture all the time. This is not weaponization. This is protecting the rule of law. We are not using the law to attack people with whom we disagree. And in fact, for us, because our work is nonpartisan and non-political, and I kind of have a close eye on everything that goes out in our name, we will never use the word Republicans and Democrats. We only talk in terms about people who are, with extreme perspectives, as opposed, because this is no longer, we're not in a Democrat Republican world anymore. We're in the world of extremism and authoritarianism, and we have to start helping people understand those words and not turn away from them, and help people understand just how dangerous a time that we are in, as Scott so beautifully pointed out. So I think when I wanted to raise that because I think we have to reject these arguments and keep showing the righteousness of what it is we are trying desperately to do.
Thanks. Yeah, I love a hopeful message, and I do want to give everyone a chance. You've got a room full of law students, and if you were here for the earlier panel and Professor Cummings talked, a lot of the questions were like, so what do we do now? Is there still law, etc. And I think it would be really helpful to hear from people who do this kind of work, this difficult work, what your words are to 1Ls, 2Ls, 3Ls, who, as one questioner put it earlier, are all going to be graduating during this administration and going out into the world as lawyers. So anyone who wants can start, but I think.
Yeah. There is an enormous amount you can do. I just want to sort of tell you two stories for whatever they're worth. One is when I was back in the very, very beginning of my career. I went down to Texas, maybe my first big case, and it was about challenging forms being used by the Immigration Service that were very complicated and only in English, and were resulting in everyone waving away all their rights, non-citizens waving away all their rights. And I went down to Texas in my 20s, a young lawyer, not really knowing what I was doing, and met with a community organizer who was working with a woman who had signed away her rights. The woman who signed away her rights was a 20-year-old woman from El Salvador. The community organizer was a woman who was same age as me, and her Spanish was better than mine, so she did the talking. And she started out by saying to this young woman from El Salvador, Lee is down from New York and he's a muy importante abogado, right? Very important lawyer. And we had the meeting, and then after the meeting, I said in a very cavalier, glib way to the community organizer, you should have said I was a muy importante lawyer. And a few weeks later, I started thinking about it, and I realized how much wiser this community organizer was than I was, even though we were the same age. That what she realized that I didn't realize at the time was that this young woman from El Salvador needed to know that someone was on her side. And not just anybody, but a lawyer. A lawyer was on her side. And that this community organizer started the meeting by telling her that I'm there and I'm a lawyer and I'm on her side. A lot of jokes are made about lawyers, some of them funny. Do not ever forget how much power you have as a lawyer, what it means to people who have a very different relationship with our government, who are vulnerable. Do not ever forget what it means to them for you to come and stick up for them. And you can stick up for them. You really have a lot of power. Don't take that for granted. Use it. You will not regret it. And I do not think it's futile for all, whether you win cases or not, you get the stories up, but part of it is just the grind. You have to push back. You can't just say, no, it's futile. And as Judge Gardner said, it's not futile. We've been winning a lot of cases. We've been winning cases before judges from every different, administration, appointed by every different administration. The other thing I just wanted to say to you, and I apologize for using so much time, is don't get overwhelmed by the sheer magnitude of what's going on. That's one of the real dangers I see for young people. Say, well, how am I going to solve all these big problems or even one of these big problems? Just do anything. Take one case, help one family, help one person. It'll be gratifying to you and it'll change that family's life forever. Just start by taking a case. Don't overthink it. Don't think, well, will this really make a difference in the big picture? Just do it. For me, some of the things I think about are those little moments with the families, not necessarily arguing cases in the Supreme Court or when I've done that or other things. I remember after family separation being in Mexico and meeting with a father and son, and the little boy, 9 years old, had been taken for 5 months from his father, and the lawsuit finally got them back together. We were sitting at a table in Mexico, and the father and son were across from me, and the father talked for about 15 minutes, and then he got up and left, and I could see the little boy lingering and trying to get up his courage. And he came up to me, and he put his hand out, and he said in sort of broken English, "Thank you for helping my family." That's something that I will never forget, much more than arguing cases in the Supreme Court. No little 9-year-old boy should ever have to do that, but that's how vulnerable these are. And so just do something. Don't worry about, am I going to solve everything? I know your lawsuits are talking about the courts and are they going to do the right thing? They will much more often than you think. There are serious people on the bench, whether they were appointed by President Trump, Obama, Bush, Clinton. They will do the right thing if you make the right arguments, but more importantly, just be engaged, help someone.
And follow that, Alina.
I'd rather not. I think what Lee said was a much more eloquent version of what I was going to say, which is two things. First, march in the streets, whether you're a lawyer or not. And then second, think about being a legal services lawyer. I got my start in legal services, and I think we've been talking a lot about these rule of law issues all day, but these are also policy decisions that are on the backs of folks with the least amount of power in our country, whether that is immigrants, folks who rely on food stamps, on Medicaid for healthcare, on public housing assistance. And doing that kind of work, I think, is a project of the pro-democracy movement, recognizing that folks who need lawyers, who need access to the culture of power that we have by virtue of our degrees, is one of the most important training grounds that you can get for both understanding and doing the work of democracy.
Can I add something? I actually, I haven't spoken to students since Trump was elected, not in this kind of form. In a sense, you're facing the best of times and the worst of times. You know about the worst of times. We have been talking about that. That's what the discussions was all day. But in one sense, there is a clarity about your role now. I went to law school in the midst of the civil rights movement and the women's rights movement and the movement for racial justice, and everything I learned in law school, I matched against those issues, and it animated me in my career from that moment until now. There were other generations for whom it was a much more ambiguous picture. There is clarity now. There is need now. And you can contribute just about in any way that you can, but you have to contribute. I might add your generation in particular has to contribute. Professor Yaroshevsky and I are going to start a TikTok channel to try to figure out how to do this, and I can do it. I can do it. It's really not a thing. This is not rocket science. So if you see some totally loopy TikTok channel, but everyone has to do their part. There's a clarity for this moment that I think we can't back down from.
I think the capacity in this room was, I think, 170 people, so that's 170 TikTok followers. Lauren, do you want a few words and then to close this out, and then we'll go to Q&A from the audience?
Sure. Just, I guess, in terms of trying to be edited, Lee, you're not supposed to make people cry when they're about to speak, I should say, but your words were beautiful, and all the advice you all gave was, the three of you gave was spot on. I think I will add something to that, into the notion of power for law students, which is that you just have to understand where your power is. And a lot of times that can be in your role as somebody that ultimately law firms may want, and how are you using that power and your voice with who is doing interviews, where you're going to go, how outspoken you may or may not be. I know that's hard. But if you work in allyship with your fellow students who think like you and care about the things you do, and the wonderful professors who are involved in this event today, and I'm sure exists throughout the law school, that is a very dynamic source of power. And the last thing I want to add to that, it's something that we don't talk about because it may feel prosaic, but think about participating in bar associations. Number one, it will be an opportunity to maybe do some of the more gratifying work in your life as a member of a bar, to be with like-minded people and work on some of the kinds of projects that you care deeply about. But they need young lawyers. They need law students, and they are listening to what you have to say. Join en masse, use your voice, and make them change with respect to talking about these issues, which so many are afraid to do. I had served as the vice chair to the ABA task force. I was on the advisory commission to the ABA task force on American democracy, and we were very engaged in moving the ABA to use its voice early in this year to speak up on behalf of the rule of law. And I congratulate the ABA president, Bill Bay, for listening and paying attention, and then doing far more than any of us could have asked, at great risk for himself and potential membership. But we have all stood behind him. We're very proud of what he has done. And we had an influence. And I think we can all have an influence on our organizations and our groups by speaking up together.
Thank you, guys. We'll do Q&A now from the audience. I know we have our Q&A folks. Thank you. So if you put your hand up, someone will come around with the mic.
Hi. First, I wanted to say thank you for all that you guys do. It's clearly made a strong impact on people's lives. And I wanted to ask, being that you're currently being inundated with many, many legal issues, in the current administration, what would you want to see out of a future administration to prevent these abuses of law?
We have, this is a big ask. We have to do something, we have to talk about constitutional change at some point. I believe that Jill Lepore wrote an article in The Atlantic about how we have the benefits and the disadvantages of a written constitution, right? We have a written constitution, so we believe that it cabins official power. We had trust in it that it did, but it is vague. It is capable of numerous interpretations. And so you have the best and the worst of a written constitution. So the interpretation that lands in the Supreme Court is the authoritative interpretation of a document that actually says very little. So the big picture is, when things are appropriate, we have to talk about constitutional change, because so much of, someone wrote an article that I just read, which gave me chills, which said that the only bar to getting rid of judges, the Constitution ensures the independence of the judiciary. Judges hold office during good behavior. What the hell does that mean? We have provided that with a meaning through precedent. We've said that the only vehicle for getting rid of judges is impeachment. That's not in the Constitution. So we're going to have to think about what the norms and the ways of cabining official power are, and be explicit about it. That's one place to start. I got others.
Could I just add a little? So, yeah, I mean, that's obviously, as Judge Gardner said, that's a big question. And I was interested in Judge Gardner's answer about what we can change in the Constitution or interpretations. But I think the other big question out there is, how much is about rulings and what the Constitution says, and how much is relying on the good faith of those people who have to implement it, right? I mean, there's no question that the executive branch has to follow judicial orders under our Constitution and how it's been interpreted. But right now, we're seeing very tricky situations where the administration is not outright yet saying we refuse to follow court orders, but they're taking enormous steps to circumvent them, what we view as sort of blatantly defying court orders. And Judge Boasberg, in the case we've been talking about, the Alien Enemies Act, has found probable cause of criminal contempt. The government is appealing that. We're going to see how that plays out. That could end up before the Supreme Court very soon. But so that's the other part of it, I think, is not just what the Constitution says, but who's interpreting it. And that's a big issue. You see people talking about this presumption of regularity and the assumption that we defer to the political branches because they're acting in good faith. And if that breaks down, then what happens? So I think that's the other piece of it. And I realize these are sort of abstract answers to your question, but a lot of thinking has to go into what are the guardrails that will actually will enable sort of this kind of thing not to happen in the future.
You've got an intergalactic to-do list. All of it.
Can I add one more thing to that list?
Yes, of course.
Supreme Court reform. I think that the last 6 months have shown us the dangers of what happens when you have an extremist wing of the Supreme Court that is able to smother out other voices. And what this can't, this is dangerous. And I don't think we're paying enough attention to what the Chief Justice has done to enable what is happening in this country right now.
So, I think everybody now knows who I am. So and that I teach civil procedure. So I'm intrigued by procedural challenges, one of which is the shadow docket. And if you haven't seen it and or read, Adam Liptak, New York Times, has done some fabulous work on this front. And I want to get a sense from you all, to what extent is there a procedural challenge? Is there any way to combat this dramatic increase of shadow docket decisions? And are you thinking about that at all? And if so, are you willing to share what you're thinking about it?
I mean, I think one thing that all the litigants are thinking about in every case now is a PI worth it? You know, does it make more sense to go a little bit more slowly, see if we can do something like expedited summary judgment, expedited, discovery, things like that, rather than going up on a preliminary injunction motion that just gets stopped immediately. And I think those kinds of calculuses are really difficult, especially when you're dealing with terrible situations that are rolling out in real time. I think take the agency dismantling cases. The folks at the Department of Education, the folks at agencies across the government, USAID, CFPB, those folks are fired. There is no agency for them to come back to, no jobs for them to come back to. That is done. But I think there are some other cases where, rather than going an emergency route that is so vulnerable to being overturned so quickly, there may be other ways to go, maybe not quite as quickly, but ways that might still be able to get a little bit further relief and hold up longer.
Jennifer, I'd actually like to hear from people who are civil procedure experts about the way to change this institutionally. I mean, could there be a bar to the use of a shadow docket decision as precedent? Last thing I wrote was a piece called No Apologies, in response to one of the judges of my court, Judge Young, apologizing because Justice Gorsuch, dressed him down for disobeying a shadow docket order that was incoherent, in my view. And another judge took a different approach. There's a wonderful footnote 9. How nerdy can I get? To the decision about the Harvard grants. Her judge's name is Allison Burroughs. And she wrote a footnote that said essentially, defying the Supreme Court, how could we be possibly defying orders and opinions that are less than coherent? She said, I think she said clear. And so that was one effort to address that. But if these did not have precedential value, because they were not the subject of briefing and oral argument, they would still be bad, but at least they would not be binding in the way that the court is now moving to do. The part of the problem is a structural problem because of what Trump has tried to do, which has been unprecedented. It basically has engendered, 300 lawsuits around the country. The Trump administration then appeals on an emergency basis, and a group of 9 justices who do not have the capacity to deal with emergencies, who are really structured to deal with lengthy decisions and oral argument, are now being put in this position. So either the product of their work has an asterisk by it, which is this is not precedential, or we have to figure out some way for emergency matters to go elsewhere than to the Supreme Court.
I have one. Just from a civ pro angle, I mean, I think the other approach that we've seen some litigants do, both in the first Trump administration and the second, is when you're faced with a shadow docket decision that has no reason, you go back to the district court and you kind of move for another PI or some version of that, and you go up on another version of that. And we've seen folks try that with different degrees of success. But when faced with something that is totally unreasoned, you can try to force the court to give a reason, Or you can say, okay, well, if it was this, then here's an alternative and here's another path forward, and see if you can get provisional relief in another 2 weeks, another 4 weeks, which means something.
From the pathos of tears coming up to nerdy procedural stuff, please join me in thanking this panel. We're going to take a 5-minute break. There's coffee and snacks right across the hallway. Yeah, so please help yourself.